Now, without further ado, I'd like to invite today's speakers from Hadef and Partners to talk about commercializing your intellectual property rights. We have Victoria Woods, who heads Hadef and Partners Commercial Group in Dubai, with extensive experience as a practicing solicitor gained from both the UK and the UAE markets. Victoria advises clients on cross-border transactions involving distribution, franchising, and commercial agency, on issues arising under outsourcing, consultancy, and service arrangement. So I'll ask Victoria to turn your webcam on. And we also have James Dunne. Hi, Victoria. Good to see you. And James Dunne heads Hadef and Partners Trademarks and Brand Protection Practice with over 10 years experience in intellectual property law in the UK, Australia, and the Middle East. He has extensive experience in brand counseling, trademark portfolio management, trademark clearance, prosecution, and enforcement across the Middle East and internationally. So thank you very much, James and Victoria. And what I do is stop sharing my screen and you can start sharing your screen and the stage is yours.
Thank you so much, Rahul. And thank you for the very kind introduction and also to everyone attending here today. So I'll just share the slides on screen here. So just we'll get them up. So, right. Fantastic. So this is a bit of an overview first, and you read on screen. Hadef & Partners is a full-service independent commercial law firm based here in the UAE. We have approximately 100 lawyers between our Abu Dhabi and Dubai offices. And we'd invite you to have a look at our website, www.hadefpartners.com, to get some more information on each of the practice areas that you can see on the slide. If anyone on the call would like an introduction to the heads of department for each of these practices, please do let Victoria or me know. So moving on to today, before we begin, we're going to have a quick vote as a rapid-fire quiz question. And time is limited, so there'll be 2 questions, no prizes, unfortunately, with a 15-second answer time for each. But Rahul, if we can have the first poll question up, please. So quite interesting. For those people who said yes, perfect. Today you'll learn probably a little bit more about the commercialization of intellectual property. And equally for those who've answered no or unsure, you've definitely come to the right place. So if we can have question number 2, and I think that's probably it. And the results are yes, no, and unsure. Again, quite an interesting split. But again, by the end of the session today, what we should be able to help you identify is either what you're doing, what you need to do with regards to the commercialization of your IP rights. So we'll close that. So moving on, what's the definition? So we put on screen here what we believe is a fairly accurate indicator of what commercialization of intellectual property is, and I'll let you read that. Ultimately, what it is, it's to leverage an intellectual property asset to exploit it for profit, grow the business, obtain increased market share, or combination of any of these factors. So for any of you who've attended some of our previous sessions, you'll recall we've given an overview in some detail of what constitutes an intellectual property right. And you'll see on screen here the top 4, as I call them: trademarks, patents, copyrights, designs, but also trade secrets as well. I'd say for everyone on the call in your businesses, you will all have a trademark or many trademarks associated with the businesses or the entities in which you're placed. And depending on the nature of your activities, equally you may have IP rights covering patents, copyright, designs, or even trade secrets. So the issue, of course, is what can you do with these and how can you commercialize them? Now, of course, to commercialize something, there must be an appeal in that particular IP asset. And you'll see on screen here some sort of well-known household names from various industry sectors. And over the course of the presentation today, you'll see that my presentation will be focusing really on a lot of names that you'll know and brands that you certainly may love. And Victoria will be going to a bit more black letter law detail about what is needed from a contractual point of view to cover the assignment or, the agreement governing the licensing of those IP properties. So if we look on the screen here, we have Walt Disney, and we all know who they are, and they will license their IP rights, so characters, branding, indicia, trademarks across a range of different goods and services, ranging from T-shirts, greeting cards, through to bed clothes. iStock in the middle licenses photographs for use on the internet and other places. Spotify, who we're probably all well familiar with, have entered into multiple licensing deals with various recording studios and song databases, including most recently with Universal. On the bottom right, you'll see where probably the best exposure that we all get to licensing in action in the local food court. And you'll see many of the brands that are licensed there with the trademarks on the lower right-hand side of the screen. Last but not least is a snapshot of patents. And you'll see here that Microsoft have been generating approximately $1 billion a year in the licensing deals they've had for some of their patent portfolio to Samsung. So as you'll see, there's certainly quite large numbers with this. But of course, having established that there's an appeal in IP, the question is, well, how do you value it? Now, one of the conceptual leaps that many people have to make is that just because you can't see it or pick it up doesn't mean that it doesn't have value. To the contrary, it's often the case that intellectual property rights are equal to or exceed the value of the commercial operations with which they're associated. So for an IP asset to have a quantifiable value, you'll see that it should be related to criteria. It must generate a measurable amount of economic benefit to its owner or user, and it would also enhance the value of the other assets to which it's associated. So again, if you think about our food court example, the particular brand appeal of a certain fast food chain over another indicates that there's an inherent value in that in relation to the fast food services. Now, of course, the valuation is very, very important because if you don't know the value, how are you going to exploit it? And Victoria will be talking about royalties and calculation of that later on. But of course, the other question is, well, how do you value a piece of paper? And I say a piece of paper because certainly until recently, most IP registrations, such as a patent or a design or a copyright trademark, would be enshrined in literally what was a 1 or 2 pieces of paper. So on that scale there, which is on screen, it's a question, does a patent or a trademark registration outweigh the value of a warehouse or a multi-million-dollar production facility? And the question is, in some cases, yes. The important thing to realize is the method of treating that particular asset is no different, be it an intangible asset in relation to intellectual property or tangible asset, such as a warehouse or a production facility. And it's very important to understand that by knowing the value of your intellectual property, the decision to commercialize becomes a lot more efficient. You have a place value on it, and as a result, you can make a decision, and an educated decision, about how much you're going to charge to commercialize that IP by way of license fees, royalty payments, and so on with a third party. And of course, the first step to value what you've got is you need to understand what do you have. And the flowchart on screen really is the step-by-step approach to doing an audit of an IP portfolio. And what I'd invite you to think about is an audit is no different than a stock take in a retail environment. Many of us will have seen people in grocery stores counting products on shelves, or indeed for any of us in our offices, when there is an audit about how many computers, desks, chairs, and so forth that the business owns. It's no different. It's just a different subject matter. So you'll see there's 2 stages, stage 1 on the top and stage 2 on the bottom. So the first thing is to identify what's the purpose, what's the audit for, and that will define the scope about how far you go and how far you drill down into the particular information. So it may be, for example, are you looking at only one set of IP rights, or are you looking at an entire business unit and what IP rights that they hold? In relation to the information, this is very important. What's being used, by who, and where? And this requires a dialogue and interaction with the business to understand really where and how the different jigsaw pieces fit together. With an audit plan, fairly simple, it's to map out what needs to be done and when. And then moving on then to the obligations. And this is very important. So it may be, for example, that some of your IP assets are already subject to a limitation. They may be subject to license themselves, there might be a mortgage on them, or there might be an agreement to be signed with a third party. And this due diligence is part of the audit. All collectively makes the process far simpler. Last but not least, the timeline. When do you need to have this done by? Having mapped out all of this, it really then moves to the next stage of rolling out the audit. And it's reviewing what IP assets have been revealed. And that will look at things like their scope, their type, where their coverage, the duration of the rights. Are they due to expire soon, for example, for a patent, or are they due for renewal in the sense of a trademark, for example? And any deadlines might be in play. Equally, it's very important to look at the ownership. As businesses become larger, and certainly in the case of multinationals, it can be the case that the different IP assets have been parked in different divisions over the years. So again, this will help get a roadmap, if you will, about where the IP assets are actually placed. It's knowing what's really in the cupboard. From there, it's a risk analysis. And is it the case that any of the IP rights are being infringed by a third party? Equally, are any of your rights infringing the rights of a third party? So it's a two-sided approach with that. And last but not least is to consolidate the results. Are there any gaps in the protection? And we'll talk about this later, where there's use taking place, but not necessarily with any accompanying protection. Equally, what steps can be taken to improve the workflow? And I think the picture at the end of the workflow really shows what the goal is. Rather than the untidy mess and not knowing what's in each folder, you're looking at a very neat, categorized, and easily digestible understanding of what you actually own, what you have, and what obligations subsist in each of those. So there are three general types of audits: general purpose, event-driven due diligence, and limited purpose. So dealing very quickly with these, you can see on screen, the general purpose is very broad in nature, and normally this is a snapshot, normally when a business has a quick question about what it might or might not own. On the other hand, the event-driven due diligence is quite a bit more detailed, and you see this very commonly in franchise agreements, when an entity is looking at entering into a franchising agreement or to franchise the IP assets that they own. And this will look at not only the value of the assets, but also the risk of those IP assets within the business. It's also increasingly common, certainly where there's IPOs, where these EDD audits are used for this evaluation for either licensing, an IPO, third-party investment, a merger or sale. And again, it's really important to think about that with the value of an audit is that at any point in time, you really should know what the assets of the business are, whether they're tangible or intangible. And it's the case really that having a well-organized cupboard rather than a messy pile of papers certainly makes the business and indeed the IP that's being commercialized far more attractive to the potential partner that you're going to enter into an arrangement with. Last but not least is limited purpose audits, and these are generally more specific. We must commonly carry these out when there's going to be litigation, either inbound or outbound. And it's really to look at whether there are any holes in the protection, shall we say, and it is for a very specific purpose. The other benefit of an audit is also to identify where you might have some dormant IP. There might be, for example, older legacy brands. There might be some patents that aren't being used anymore. And instead necessarily of licensing them, it may be a case that the business may want to sell them because they're not being used anymore. The question, of course, there is, from a revenue stream, do you take the one-off payment by an outright sale? Or alternatively, do you engage in a longer-term relationship where you can generate ongoing fees and revenue through a licensing arrangement? And again, this then will determine the nature of the contract. As Victoria will talk about in more detail, quite a bit more detail when you're looking at the licensing of an asset rather than the outright sale. But now that you know what you have, well, what's the worth? So many of you may be familiar with the World Intellectual Property Organization, which is headquartered in Geneva in Switzerland. And they've very helpfully put together a list, which you can see at points A to G, as to what are the assets or the criteria that apply to an IP asset in order to be valued. And I'll let you have a read of those. On the right-hand side of the screen is what I think is really the quick 5-point summary. What is there? Where is it? Who owns it? What's it being used for? And that will lead to the value. And of course, as you can see, this wouldn't be possible, or at least possible to do in any meaningful way, without having conducted first an audit in the first place to understand what's in the actual cupboard. I won't go into great detail, save insofar as to give a quick overview of the valuation methods, but there are largely three: income method, market method, and cost. The important thing to bear in mind with this is that the method that's selected should be the most appropriate for the particular IP right that's in issue, and also the framework. And by that, I mean the owner, the jurisdiction, the purpose, and the type of IP in which it exists. Helpfully, there are many specialist firms out there who will provide IP valuation services, and we've selected 4 just by way of example to appear on screen. There are many more. And each of these entities will actually look at from an accounting perspective and other indicia as to what the weighting of the value of that IP asset is. So, of course, again, with the value of the audit, you can see that it's a 2-step process. It's impossible to value something unless you know what you have. So the income method is the most commonly used method of IP valuation, and this values the asset on the income expected to generate. Now, this is normally quite easy to do where you have, for example, a positive cash flow. So when, for example, you see, as we'll see some examples later on, valuation of entities who engage in licensing, that is projected really from their revenue streams, but it is the simplest way to look at it. It's also a fairly good indicator of the health, in that if there's positive revenue stream, there is the inherent appeal that I mentioned earlier. And from that, potentially the capacity to exploit that IP through licensing in either your own market or into other markets overseas. The second is the market method, and this is a bit more different, and this is where it looks at a comparison between the price paid for other comparable IP under similar circumstances in the marketplace. Now, it's fairly simple and it's based on market information, and that information can be obtained from various sources, such as, for example, official filings like company reports, surveys, licensing publications, or published agreements. However, one of the limitations of this market method is that in many cases, the actual value is highly confidential. It is a commercially sensitive piece of information. So as a result, it can be sometimes difficult to use the market method. However, there are sometimes ways and means around that to get perhaps even a benchmark. The third is the cost method, and this is actually geared towards the valuation on what it actually costs for the same or similar asset. Now, this is quite useful where the particular IP asset can be easily reproduced, but it's a little bit more harder when we don't know what the benefit of that cash flow or revenue stream is. So again, looking at the three different models, it is a case very much of looking at where is the best way and the best method in order to engage in the valuation exercise. Now, I mentioned that some of the numbers are considerable, and what you'll see on screen here is a selection of 5 different companies, and it's listed their revenue stream based on licensing activities. Now, what's very important to bear in mind with this isn't the value of the company, and it isn't the value of sales of product. It's the value that they get through licensing activities of their IP properties. As you can see from the figures, they are considerable. So Walt Disney, and these are 2020 figures, $54.7 billion in licensing revenue. And you can see in the italicized font underneath some of the properties within the Walt Disney Empire that are used to license. So, for example, the Lion King or Pixar or some of the cartoons, you'll see enter into license arrangements with certain fast food chains for kids' meals, for example, or kids' toys. Meredith Corporation, you mightn't be immediately familiar with the name, but through magazines like Better Home Gardens and allrecipes.com, and also Martha Stewart Living, they're generating $26.5 billion in revenue in 2020. Authentic Brands Group, $12.3 billion, and they own over 50 different brands in the apparel space, including Juicy Couture, Forever 21, and Aeropostale. They also, interestingly, own the likeness rights to a number of different celebrities, including Muhammad Ali, Elvis Presley, Shaquille O'Neal, and Marilyn Monroe. So you can see here that even in the likeness of an individual, there's still an opportunity to engage in licensing and derive a revenue, as you remember from the first slide, in terms of the overall purpose. PVH, and you can see the figures on screen there, operates in the clothing space, and you'll see, for example, that they own Tommy Hilfiger and Calvin Klein from a licensing perspective. Universal Brand Development was actually set up specifically by NBC Comcast, who own Universal, to license and commercialize the different entertainment properties, not only in the film space, but also in relation to TV shows. And they cover a range of goods ranging from homewares, toys, pets, electronic games, stationery and publishing. Last but not least is Sanrio. And again, you might know the name, but you'll certainly probably know Hello Kitty. And this generates $4.4 billion in revenue annually through approximately 50,000 different licensed items sold in 170 different countries around the world. So again, tremendous numbers. And as a bit of trivia, as a licensing tie-up, they've also entered into a licensing agreement with Levi's, a jeans manufacturer, to have Levi's Hello Kitty branded jeans. Now, certainly not something I'd wear, but there's certainly a market for it, and really demonstrates the fact that there are potential revenue streams even where you may not expect it. Now, last but not least, when we're talking about valuation, is the previous slide gave a snapshot of where we know there's inherent value. These are global players and well-recognized names. But what happens when perhaps the business fails or goes under? And there are 2 case studies here. So Barney's New York, many of you might know, was founded in 1923, and it was a preeminent luxury department store in the United States. Now, Barney's filed for bankruptcy in August 2019, and all the intellectual property, data, and some other assets relating to its e-commerce business were purchased by Authentic Brands Group, you'll remember from the last slide. Now, on the other hand, you've got Saks Fifth Avenue, and that's currently owned by Hudson Bay Co. Authentic Brands paid $271 million for the IP assets of Barney's and entered into a licensing agreement with Hudson's Bay, where they're going to offer Barney's at Saks. These are store-in-store locations, both real world in New York and also online on the website, where you can go to a Barney's store within a Saks store. Now, industry commentators have described this as akin to walking into a McDonald's restaurant to buy a Burger King burger. But it's shown here that the appeal that I mentioned, certainly in the Barney's brand and the Barney's goodwill, has been leveraged to the sum of $271 million to exploit that through a licensing agreement with what was historically a competitor. We spoke about the valuation and the various factors were coming into play, and certainly with the weighting on that was the goodwill and the reputation that was in the Barney's New York brand. With Debenhams, on the other hand, you have a company that has collapsed. Now, from a peak of approximately 168 stores through to its bankruptcy, you had a massive decline. Boohoo purchased the IP assets only, so none of the 12,000 staff, none of the 150 odd stores, but only the IP assets for $75.4 million. Now, of course, the question is that if Boohoo was to have bought this 10 years ago, there probably would have been a number 1, 2, or perhaps a 3 in front of that. But as you can see, the valuation of the IP assets there were diminished by virtue of the fact that while the business itself had gone into administration, there was still inherent value and appeal in the IP that could be leveraged in the marketplace. So when we're looking at the numbers and leverage, you think, well, what's in it for me? And in many cases, it'd be surprising who's actually entering into licensing agreements. So we have a look at pharmaceuticals. It's one of the spaces where licensing is actually very, very common. Now, on the one hand, we've got 2 players here, Merck and Hamley. So Hamley Pharma, which you see the logo with the trademark on the right, is a Korean pharmaceutical brand. It was founded in 1973. It's got annual turnover of approximately $1 billion with 2,500 employees. And they developed a product, and its various technical names are in the text box in the middle, but it's called fenpegdetide, and it's used for the treatment of fatty liver disease. On the other hand, you have Merck. Merck's been around now since 1871. Global revenue per annum of $47 billion with 71,000 employees. So the question for Merck is, what does Hamley have that's of interest to Merck? And the interest is fenpegdetide. The reason for that is that the drug had just passed clinical 2 trials. So what Merck had decided is, rather than investing in the R&D itself to develop a competing product, it was simpler and cheaper, rather than develop it themselves, which they could well afford to do, but commercially more sensible to enter into a licensing agreement with Hamley to essentially commercialize fenpegdetide. So in exchange for an upfront payment of $10 million, double-digit royalty payments, and potential milestone payments of $860 million US, Merck will have the exclusive license to develop, manufacture, and commercialize fenpegdetide all around the world, with the exception of Korea, which will remain the domain of Hamley. So you can see here where Hamley essentially have generated revenue stream, but also compartmentalized their own market, but have licensed the product to the rest of the world to Merck. So you can see here where there is a benefit really from a licensing perspective. Equally, you might remember when I mentioned in the benefits of an audit of identifying maybe IP that isn't being commercialized or indeed used at all. So Intel in 2019 decided that because it had moved out of the 5G market, rather than license its technology, which it does on a regular basis, it decided to sell its patent portfolio in relation to cellular and connected devices modems. And these are essentially pieces of technology that are used most commonly in mobile phones. There are approximately 8,500 patents as part of these 2 portfolios. But while the auction was announced in June, it was taken off the market on the basis that there was exclusive negotiation with a third-party purchaser. Now you can see on the right who that purchaser was, and it was announced in July of that year that Apple had paid just over $1 billion US for that IP portfolio. Apple, coincidentally, now has only in the wireless technology space over 17,000 different patents. So you can see that the value of the IP, certainly from the patent space, is certainly of extreme value to Apple and indeed any tech companies. So with this in mind, in terms of what IP do we have, where is it, how do we commercialize it, it moves really to the black letter side of things. How do we enshrine this in agreement? So on that note, I'll pass you over to Victoria, who'll take you through the second part of our training session.
Thanks, James. So the next question really to address is, what are the agreements that we're talking about when we're talking about commercializing intellectual property? They are effectively an agreement containing an intellectual property license. I've split these off into two different types of intellectual property license, because sometimes you might be familiar with seeing them in a single standalone document, and other times they're embedded within a wider, broader document and perhaps a broader venture. An IP license is effectively any agreement between an IP owner of specific rights and a third party to use those rights. So with standalone, we are looking at usually a limited grant of right to use for a particular purpose, perhaps for particular products in a restricted geographical area. Examples can be rights to use a logo or a trademark on a website, in marketing materials, usually the kind of activity that's not connected with any further commercial activity, so selling products, for example, or franchising. That's when it comes into an IP license as part of a broader venture. So again, this is often embedded within maybe a franchise agreement, a distribution agreement, etc. So it can be overlooked, and perhaps sometimes the attention isn't given where it should be to the IP license that's within that document. And when you're looking for these, typically you're going to see IP licenses in distribution, franchising, manufacturing, management agreements. I mentioned here hospitality and hotel management. Introducer refer agreements, collaboration agreements, the full list there on the slide. So really, effectively, we've already identified that there can be a whole host of potentially relevant intellectual property, and that also means that there can be a whole host of ventures which can encompass an intellectual property license, and perhaps should. Next slide. So now we're going to look at some of the essential provisions of an intellectual property license. Okay, so really our questions are what, why, how, and for how long. These have to be really with any contract, I imagine, with any drafting, this is exactly the issues that you're going to be thinking about. The main thing with intellectual property licenses, again, either standalone or within, when I'm speaking now, I'm speaking about whatever format they take. I often see quite poorly or quite vaguely defined intellectual property that's being licensed. This is critical. You need to clearly, definitively, and exhaustively define that IP. James mentioned earlier, legacy IP, there could be legacy trademarks if a general description of all trademarks of the company, or all trademarks relevant to this suite of products. So it's really important to scheduleize and really detail out exhaustively what that intellectual property is. Does it meet the needs of the parties and the intention of the parties for the venture? This comes up time and time again in these points on the slide, and always go back to that. This is an example of where this kind of a document or this kind of arrangement, an IP license within a wider agreement, is not a one-size-fits-all scenario. What about later in the term? We'll come on to that a little bit later on, but do we need some flexibility in the definition of what that IP is to encompass wider IP that might come about throughout the life of a venture? Check, does the licensor party own the IP being licensed? So many of these points, as you'll probably pick up, are relevant to both licensor and licensee. We need to make sure that the grantor of the right actually owns the right. They don't necessarily have to be the IP owner itself, but certainly they would need to be themselves a licensee of that right. Is the IP registered? James will come on to talking about the protection of IP a little bit later on, but something that a licensee will usually be quite keen to ensure is the registration, because that will protect the goodwill and the value in the mark that they're potentially paying for, or the IP they're paying for under the license. And certainly it's important to the licensor, which, as I say, we'll come on to a bit later. And what about new IP of the licensor created during the term of the license? That could be side ground IP. Again, we'll come on to that a bit later on. Why is the IP right required? Look at the intentions of the parties, the intention of the venture, and make sure that the purpose fits with that and goes no broader from a licensor perspective than is critically necessary. How can and should the IP rights be used? This is usually one of the most lengthy and comprehensive provisions of the IP license. And again, this is going to be specific to the brand in question, the venture in question. So think about the territory and also the digital territory. Sometimes it's only a grant to use in a particular digital medium. Other times it's in stores, it's in real life as well as virtually. Any exclusions or carve-outs? We're thinking here about the licensee's existing business, which may well contradict with a right of use if there's already an existing use elsewhere of the licensor or the licensee's business. Is it exclusive? This is key to a number of factors, one of which is agency, which we'll speak about later, but also it's going to be of key importance to a licensor in terms of its future plans, either itself or with other third parties. Again, does this meet all of this, meet the intention of the parties and the intention of the venture? And finally here, for how long? Should it tie in with something else? If we're talking about a wider arrangement, for example, a JV arrangement where perhaps a shareholder of a JV co is licensing in some IP rights, would that license need to continue or should it continue beyond that shareholder being a shareholder? Is there a restriction on the licensor's own IP right usage? If they themselves are a licensee, we would need to tie in the term with that right. Again, issues for both licensees and licensors. Is there and should there be a fixed term? It will provide an element of control to the licensor, but is this going to be restricted down the line? So consider renewable terms. Next slide. Brand standards and guidelines and quality control. Now, these will be obvious things that will jump to your mind perhaps when you're thinking about franchising and hotel management, for example, but perhaps not so much in distribution arrangements or in manufacturing arrangements. Really, the question here is, what do we need to impose upon a licensee in order to protect the status and the brand image? So here comes the rules of use. Are there any provisions as to brand extension or spin-off that might arise from the venture? And have these been considered in the drafting of the contract? The restrictions on mark mixing. So typically the licensee's own mark being included within a document or a label, etc., with the licensor's mark. Is this okay? Is this required, in fact, perhaps under local law? Not to use any confusingly similar marks. Again, similar to the point above in terms of labeling, but also consider business names, URLs, social media handles. Should any form of language be a condition of the use of the IP made by, under license from, etc.? And consider any modifications that might be necessary or even desirable under local law. Does the IP translate into the relevant local language? Will any changes be necessary perhaps to product specifications by virtue of local law? And prior approval of the licensor of the form and the manner of use. This is very well accepted and expected, but again, the manner and the mechanism for that approval needs to also sync with the operational use of the IP by the licensee. So consider those two. Next slide. Royalties, as you probably know, is the regular fee payable for use of an IP right, typically royalty-free if it's part of a broader venture. But if not, think about the calculation of the royalty. James mentioned earlier about IP valuations. How are you going to provide for the amount that you should be paid as a licensor for use of the value that you've generated, effectively the goodwill in your mark or other IP? Should it be fixed, variable, based on revenue? If it's not fixed, should there be a minimum royalty to ensure that the grant is actually commercializing the IP for the licensor? If it is based on revenues, what about reporting and audit rights of those revenues? Payment terms, think about clearly frequency, but also don't forget currency and currency exchange rates, who bears those costs, and VAT payable on royalty payments. Consider the goodwill generated by the licensee from use of the IP rights. There will inherently be some goodwill generated, and typically this should not and would not vest in a licensee. But again, circumstances may well dictate otherwise. Preservation of ownership of the IP rights that are licensed, however, is an absolute critical issue for a licensor. And also the preservation of brand status, reputation, image, and goodwill. The actual use and the rules of use are going to dictate and provide in a large way for the ability for the licensor to maintain its brand status. Next slide. You would typically not be permitting a licensee to register a trademark, for example, or any other IP rights being licensed within the local jurisdiction. This is not a requirement when it comes to an IP license with, for example, the Ministry of Economy, in order to make that IP license valid. There are sometimes requirements for the DED, so things like signage, which I mentioned a bit later on as well. But typically, all that is required is proof of authorization to use, for example, a mark or a trade name or a business name when it comes to signage. And I would caution licensors to get advice in this regard if their licensee is suggesting otherwise. Certainly, right now in this jurisdiction, and registration of similar to the mark that's being licensed or the IP. Verify. How do you verify that your licensee is actually using the IP in the manner and following the rules that you've dictated? Site visits, possibly, if we're talking about bricks and mortar use, watch lists to keep an eye on other trademark registrations, possibly samples if we're talking about labeling of products, distribution, manufacture of products, and reporting of complaints or allegations of infringement by third parties. Of course, there's also the usual checks, Google, Instagram, and other social media is always a good idea. So again, as typically with any commercial agreement, an IP license has a life, and its audit and its ability to work for a licensor and a licensee is very much something that should be watched and monitored throughout its life. Action on alleged infringement of third-party IP rights. Always your license agreement should dictate the process for being able to take that action, who should take the action, how, at what cost, and providing for reasonable assistance of the parties. Typically, again, this would be the licensor's right to control that kind of action, and also for it to be at its cost. Next slide, please. You would typically have indemnities to the licensor from the licensee for exercise of the licensee's rights in accordance with the license, and of course, any default. Query whether or not the licensor ought to be giving an indemnity for in the event that the IP being licensed does infringe a third party's right. Often a licensee, as I mentioned earlier, will be relying upon the novelty of that IP and the fact that it doesn't infringe anybody else's IP rights in order to pay, for example, a royalty, or to be able to generate the business that it wishes from the IP license. So this could be negotiated. And remember, VAT payable on indemnity payments. Warranties of the licensor, you would typically, of course, expect that they own the IP right being licensed. Perhaps maintenance of the registration, again, goes to the value of the IP being licensed for the licensee. And again, as I mentioned earlier, perhaps for note that there wouldn't be any third-party infringement, although this is often a point for negotiation. And think about restrictive covenants. Really, we're talking about non-competes, non-solicitation of customers or suppliers post-termination, and then whether or not there are any caveats necessary for the licensee's existing business. Next slide. Termination, lots and lots of these will be the same sorts of things you'd be thinking about in any commercial contract. Default, whether it should be immediately or notice. Ability to cure, though, really should be considered in the context of an IP license, because if a breach as to its use of the IP right has occurred, query whether or not there can be any rectification of that in terms of the damage potentially sustained. Should there be a termination right for convenience? Of course, insolvency, force majeure, we all probably have now hammered into our brains that force majeure and our force majeure definition needs to be looked at very carefully. Loss of rights of the licensor, we would typically, of course, expect that of the license as a licensee. Perhaps termination of a wider arrangement. So if a management agreement terminates, it needs to compensate at the same time needs to terminate the IP license. Possibly ceasing to be a shareholder in a JV co if we've got a JV partner inputting IP rights, and perhaps change of control. Next slide. Consequences of termination. This is again typically something that you would be considering, all of these points in the context of any commercial contract. I just pick out a couple of these from this slide though. That all sums are payable. We're not just talking now about payable to the licensor by way of royalties, etc., but perhaps also to creditors of the business if we're talking about a franchise arrangement where non-payment could still damage the brand of the franchisor/licensor. Of course, all rights will cease. You're looking really as well with your consequence of termination to try to limit as much as possible any brand or IP asset damage arising from a termination. So cooperation again is key. Certainly return of materials, brand standards, marketing materials, manuals, uniforms, delivery of client and customer lists. This is often overlooked and could be essential to enable a smooth transition back from a licensee. Return or destruction of confidential information, buyback of assets or stock, typically for franchise and distribution arrangements, and debadging. Don't forget, when it comes to debadging or debranding and this ceasing of use, it's very good practice to set out prescriptive processes and actually call out things like websites, phone numbers, social media handles. Also, the rights of access to the licensor if the licensee fails to comply with any of those. Typically, you would give timelines, a very clear process post-completion, and the ability, as agreed between the two parties, to take action for non-compliance. Again, we're looking at mitigating and limiting the risk of damage to the brand by virtue of not facilitating a smooth transition. And transfer of any required registrations. I mentioned there's no requirement to register a license per se to be valid, but there might be ancillary registrations depending on the nature of the products. Next slide. I just want to spend a couple of minutes looking at some often overlooked issues. I'm conscious of time, so I'm going to just give you a bit of these first two slides are just to give you a bit of detail on what we're talking about here. Background is everything that's in the collaboration. So it might not at the time existence later down the line. Questions here are going to be who's going to own it? Would it be a JV co if the IP, the background IP was being licensed into there by a shareholder, for example? It could be the licensor if the licensee perhaps is a consultant developing marketing materials, an app, a website. It's very rarely the licensee when it comes to foreground. And beware of joint or shared ownership. This is not something that's straightforward, and typically the safest way, if this is a commercially agreed term, for a JV co or SPV to be established purely for ownership of that new foreground IP. And of course, your assignment provisions, ensuring that whatever you have decided about who owns that is properly documented and perfected within the document, within the IP license itself. Next slide. So side ground is anything on the side, produced outside of the project. Again, questions about who ought to own this and considerations in advance of that if it's anticipated within the IP license. And post-ground IP, relevant to the project perhaps, but produced after. Next slide. So other overlooked issues, effective date. Has the IP actually been used or been being used by a licensee already? This is very often the case when parties fail to formalize the arrangement. So make use of the drafting of your formal document and the effective date to capture that pre-contract use. Think about federal agency law. Quick recap on the definition: effectively, representation of a principal by an agent. Clearly, a licensee satisfies that criteria. So if there is exclusivity, if the licensee is 100% UAE national owned, there is a potential for Ministry of Economy registration of the license. That might be the registration of the franchise with the license within, or again, the standalone license agreement. This will have impact on the termination provisions and perhaps give, most likely, I would say, perhaps gives the rights to compensation on termination. Civil and Commercial Code agency should not be overlooked. It's, as you might know, it's a lot less, has a lot less of an effect, perhaps, on licensors in terms of compensation and termination provisions than the federal agency law, but there are still requirements within the Civil and Commercial Codes dictating that termination must be on reasonable notice, not at an inappropriate time, and failing which compensation could be payable. Next slide. So the few other final points to flag. Third party, is there any third party IP in that foreground IP that's being created? Do licenses need to be granted when you're thinking about who's going to own that IP? Governing law and jurisdiction, when it comes purely now to intellectual property protection are the remedies that a licensor are going to require to mitigate its damage available under the governing law in the jurisdiction, and do they meet the needs and expectations of the parties? James is going to talk about this, but registration locally, this is going to be the foundation for an ability to enforce and protect your intellectual property rights. Client and customer lists, question about who owns them. These are, again, I mentioned, very often overlooked. It's a good way to capture this, as I mentioned, is in your post-termination provisions, but these can be quite comprehensive provisions incorporating data protection and confidential information provisions within the contract. I mentioned data protection already. Also think about your staff personal information that may be disclosed during a venture, and whether or not there is intellectual property in any sensitive, confidential information disclosed between the parties. Include that within your clear definition of the licensed IP. And consider whether any step-in rights are required. This is specifically looking at things like franchising or perhaps management agreements. But be aware of issues potentially relating to the ability to assign a lease of a franchisee or another licensee. Typically, that's not so easy. And final couple of slides. Boilerplates. Again, I don't know about you, but I always look at the boilerplates, particularly when I'm dealing with cross-border transactions, because very often they've been sat there in a form of document for a long time and possibly been overlooked. Again, not going to be the same as the boilerplates in perhaps other commercial contracts you might have. So think about assignments, sub-licensing and transfer rights. Are you going to allow this as a licensor? Is this necessary from the licensee perspective? If you do permit this, think about what are the obligations of the licensee vis-a-vis the sub, and how can you retain control of the manner and use of the IP, verify that that's okay, retain visibility of any royalty calculations, and maintain confidentiality. Think about the indemnities in this context in terms of the activities of the sub, and make sure that the all sub-licenses are going to terminate immediately when the master is terminated or expires. Think about further assurance. This, you would typically have any documents requiring to be signed, this kind of wording to ensure that your assignment provisions of IP, thinking now about foreground, sideground, etc. IP, are going to be effective. Entire agreements, you're looking at the wider arrangements if and to the extent they exist. Which could again be JV, collaboration agreements, management agreements, technical services agreements, for example, under hospitality management. And the next slide. Last few here are no partnership or agency. You would typically be including this anyway. It's boilerplate, as I say, but this is particularly relevant to agency laws. And of course, the ability or inability, we should say, to commit a party, which is pretty well accepted. Force majeure. Look at it again. Is it relevant? Are there definitions of what a force majeure event is are relevant to the licensed IP and the activities envisaged? Are the damages going to be adequate? So think again about alternative remedies and governing law, and that wording. Any court of competent jurisdiction, a party could bring a claim before in the event of enforcement of its IP rights. This is again pretty well trodden. But think about that in the context of your general governing law and jurisdiction clause.
Thanks, Victoria. So just in the final few minutes, following on from Victoria's sort of exploration of the relationship between the parties, what's the position of the IP in the wider context? And you see here the importance of protection. It is very much a ring fence. And the question is, what's your business? Is it the one on the bottom left, or is it covered completely by essentially a very broad suite of IP rights? And it is really a case of looking at the value and need to protect those rights in the market. Equally, other markets in which you're going to operate, do you have sufficient protection in place there for your IP asset when you're going to commercialize it? If you enter into a licensing or manufacturing agreement, for example, in a third-party country, one of the things that COVID has identified is where supply and manufacturing chains have been disrupted, there's often a need to move to a new manufacturing location. So as you see with the red box, the question is that does your new manufacturing jurisdiction have sufficient protection in place? This isn't only to protect the brand itself, but it's also to keep, where possible, the infringing products within a particular market without it straying outside into other markets overseas. Now, for many people, they view things like this as quite humorous, and you can see famous brands have been copied and ripped off. WhatsApp or Armand hatches rather than Arm and Hammer, for example. But the importance of protecting the IP goes far beyond the humorous. It's actually a damage to the value, damage to the goodwill, and potentially damage to people. So the fake industry at the moment is estimated to be in the region of $650 billion per year across all industries, including automotive, personal care and beauty, and also pharmaceuticals. And you'll find that some of the ingredients that are being used are actually toxic, or in the case of lithium-ion batteries, potentially life-threatening. And you'll see an effort made by Makita to educate the public in terms of the damage that can be done by fakes. Equally, setting up your border controls, your watches that Victoria mentioned, making sure that you know what's going on in the market provides you the ability to protect the IP rights, both only for your own benefit, but also for the licensing arrangement that you're entering into. The question, of course, who bears the cost will depend on the nature of the licensing agreement, as Victoria mentioned. But this is part of another sort of holistic shield around the IP that must be put in place. Lego is a really good example of an entity that uses both protection, licensing, and enforcement. So it has registered patents, trademarks, copyright, and designs in many countries around the world. And you'll see is the growth of the brand from the earlier models of the top to the lower bottom left and right, plus also the list of licensee entities in the table on the left-hand side of the screen, is that they are leveraging essentially their goodwill in also other properties to generate commercial revenue for both themselves and the licensing partners. Through registration, they are policing it and quite effective at it. And perhaps the best known example of this is with regards to Lipen. And you can see here, this is a company that was founded in China in 2015, but shut down in 2019. We're essentially selling fakes. And you can see here the Lego Technic rather than Lipen Technician or Star Winners, for example. Helpfully, action by Lego resulted in a $13 million fine and a 6-year jail sentence for the prime instigator of the Lipen company and the founder. Now, very quickly, the way to really think about this as a bubble or shield of protection is set out below. The important thing to realize about this is your commercial enterprise is extended to the future, and the scope of protection that applies to them will depend on the particular IP right. And you can see here that from designs, then longer patents, copyright, and of course trademarks at the end, provide you the ability to protect various IP assets for many, many years. So it's a question, as Lego does, of making sure that you've got the right protection in place and then bringing it to bear against third parties who might be infringing those particular rights themselves. So in closing, I'll pass you back to Victoria, who will just run through the checklist.
Okay, so without going back through all of these points, and I would mention at the head of this, all of these will be available in our Know Your Stuff handout. If you've been to our in-house Congress talks before in person, you'll know that we produce a handout which is effectively a short summary for your use, hopefully, of some of the topics that we've covered, but also it's very user-friendly, it's non-legal language, and we intend for you to be able to disseminate that to the wider business to the extent that the issues that we've covered might be relevant to them. So business development, sales managers, contracts managers, etc. So quick canter through these. First off, does the arrangement have an IP element? Probably, I think is the answer. What's the IP right being granted? Clearly define, encompass current and future use, protect, register, enforce. Think about the background, foreground, IP, ownership, usage, and define any IP that's anticipated to be created and what the process for ownership of that will be. Set out comprehensively the permitted use of the IP. Licensee and licensor ought to be focusing a lot of attention on these provisions to make sure they reflect what's needed. Next slide. Final slide here is the geographical and type of medium rights, duration, milestones. All of these will go within the permitted use, and again, something that should be focused on by both parties. Think about warranties, indemnities, and payments, termination, post-termination obligations, and IP disputes. This is the no one size fits all. I would caution against transporting these from other commercial arrangements. Certainly consider tie-ins, step-in rights, and obligations for debadging and debranding. So finally, as I mentioned, do email us, either James or I, or the office, any of your contacts for the Know Your Stuff handout. We'd be very happy to make that available. I'm hoping we have a little bit of time to answer a couple of the questions we've had in. So
yes, Victor, we have some time. Yes, please continue.
Thanks, Rahul. Okay, so I just wanted to address, I'm just bringing it up now, when exclusivity could be considered as unfair competition. Thanks very much for that question. Great question. Exclusivity generally and the topic of competition. As you might know, the competition law defines an anti-competitive act as an action or an agreement or a requirement or a condition in a document which has as its intention or effect the ability to limit, restrict competition in the market. So here we're talking about really consumer protection. Exclusivity, along with competition law, is a really hot topic. As you might know, a registered commercial agency is carved out of the application of the competition law, and therefore the provisions and the restrictions within competition law don't apply. To the degree that there is an unregistered agreement, there will always be a risk that exclusivity, in my view, will be considered to be anti-competitive. And it will be a question of analysing the effect of that exclusivity and whether or not in its effect there is indeed a restriction or a limitation on competition in the market. I would say the competition law, if you've had a look in there, does quite helpfully in a couple of articles list out examples of what certainly would be considered to be anti-competitive. And it would, I'm afraid, need to be a case-by-case review. That being said, as we've already explained, IP rights are essentially value and assets developed independently by a party with their own investment and are proprietary. So it's fairly well accepted that the right of the owner of a IP right has the right to license its use in quite a broad manner as it deems fit. But again, it cannot be guaranteed that the effect of that will not be anti-competitive, and that would need to be looked at quite carefully if there are concerns.
I see there's a second question, which is a bit more detailed, so I'll read it out. Thank you again for this. In case a software company owns a trademark in the UK on a word and logo, and it licenses its product software on a SaaS basis, software as a service, does that mean it falls under the commercialization of IP? There's also a second part to the question, so thank you for this. In case the word marks of the product software trade names are also registered on the classification of software, again, does this mean commercialization of IP? So there's a couple of different issues in that. First and foremost, yes, there's definitely commercialization of IP happening. The licensing of software is something that Victoria specializes in, but if I focus on the trademark side of things, the first thing that jumps out is that the trademark is in the UK. Now, if the license agreement is being entered into in other territories, there may be unregistered rights in that particular trademark in those countries, but I wouldn't place a lot of weight on that. As mentioned, it is far easier and cheaper in the long run to have a registered right in place where you're using or intending to use a good or service. So if you think about the global map that was in one of the slides, really what you want is at the end of each of those arrows is that there is a protection in place. Equally as well is that if the trademark and logo is to be used by the licensee, there will often be guidelines set, as Victoria mentioned earlier, about the form of the use. So it's very common for example, a licensee to decide that its color branding might be, say, green and blue. And it also wants to make sure that because everything fits into the house style, that it will also modify your trademark. And this is the important thing to remember. It's your trademark, not theirs. So as an issue of control, you would enter into a license agreement in terms of how it's used, where it's positioned, the colors or variations that are used with it, and also things that are prohibited. So again, co-branding, where, for example, their trademark and your trademark are merged together. So you'll often find that there are quite extensive guidelines in terms of what can and cannot be done under the licensing agreement with regards to that. What I'd also say in terms of registration is the warning sign that immediately jumped out to me with that question is do you trust the licensee? We regularly deal with situations where brand owners come to us to say that their licensee has, to help, sought to register the particular trademark or logo or the particular IP right. And it is a case really that from a business perspective, if you're going to engage in any licensing discussions, make sure, remember the audit, that where you're talking about and what you're talking about is that you have control of the board rather than the other party. Because you'll often find if there's a falling over, or alternatively, if they find out that in fact you don't have any registered rights, that's a potential point of weakness, not only leverage for any discussions, but from a licensing perspective, they'll want certainty. And as Victoria said, the importance of registration. It's the value that they see in entering into the licensing arrangement with you and your software company is also tied into the protection that lies within the IP rights that they're going to be licensing. So I hope that answers that question. It was certainly covered quite a lot of ground. So thank you, whoever wrote that.
I think I'd just jump in as well if I can. And I think at the beginning of that question, there was a reference to logo and trademark perhaps, but also, of course, the intellectual property should also be flagged up within the drafting and the definition of the licensed IP, of the IP and the software too. James, did you have, I think there were maybe a couple of other questions that you might.
Yeah, one of the ones I've seen, and it's, I think, a very recent one because of recent news. I've been asked, I've seen that, what did they say? I've seen that the UAE is signing up for Madrid. What does this mean for trademarks? That's actually quite an interesting question and follows on really on what we just discussed. So what Madrid is a system of centralized filing, and it means that a trademark owner in a particular country, soon to be the UAE at the end of this year, can file a application through WIPO, you remember me mentioning them earlier, in Switzerland, and it will designate different countries, essentially saying, UAE Trademark Office, please tell WIPO to tell the trademark offices in the United States, United Kingdom, Russia, and Australia that I want to register my trademark, and maybe for software, if we use the last question. Now, the benefit of that is that it essentially cuts out the need for local agents in each of those countries to file the trademarks for you. And it does generally make the process of portfolio management easier. So again, an audit is also easier. However, there's not necessarily a one-size-fits-all. So there may be some cases that, in fact, while there's a benefit of Madrid, it's sometimes easier and quicker to file directly in that particular territory. And this could be for a number of reasons. Of the GCC countries, at the moment, Bahrain and Oman are the only two countries that are signed up to Madrid. UAE will come in at the end of this year. So what that means is for Saudi Arabia, Qatar, and Kuwait, that those countries will continue to have national filings where you will need to use a firm like us to instruct a local agent or have someone on the ground. The important thing to remember with Madrid is if an objection is raised or an opposition is filed in a particular country, then you will need to appoint a local agent anyway to defend your interests and respond to that. So it's quite a complex area, but it is groundbreaking. I would say that the takeaway from this is it's really showing the commitment of the UAE to protect IP rights and also provide a framework to facilitate the commercialization of IP rights. So that certainty of ownership and the ability to carry out businesses, certainly one that I think the UAE has certainly demonstrated with the accession to Madrid.
I've also had a question. Hopefully, I have time I'd like to answer as well, if
Sorry,
we can.
Victoria, we have 1 minute, so please make it brief.
Okay, will do. No pressure. How do I include new IP in my license agreement? Okay, great question. It's all about the definition. Scheduleize the IP that's in existence and being licensed at the day, or the effective date, and the commencement date. Include in your main body definition that it's that IP as may be amended by agreement in writing by the parties from time to time. Have a signed copy of the updated schedule at the relevant time, and ensure you remember to include that at the back of your license.
Great. Okay, wonderful. Thank you so much. Now, this was a very, very information-packed session. Thank you, James, and thank you very much, Victoria. For the attendees today, if you have any further questions, or if you would like a copy of the slides for today's presentation. In fact, also, if you'd like to receive the Know Your Stuff handout, please email Victoria and James or call them directly. Their information has been pasted into the chat box, and You can see it on your screens as well. So yes, thank you so much again. And we hope to see James and Victoria, both of you, at the perhaps an in-person event, in-house Congress next year. Thank you very much again.
Thank you.
Now, that brings us to the end of today's session, actually to the end of the UAE in-house community eCongress. A huge thanks again to our co-hosts and sponsors for this year's virtual event, Al Suwaidi and Company, Amarella, Gibson Dunne, Hadef and Partners. And thank you very much to all the panelists for our various panel discussion, as well as all the support staff from all the firms that I just mentioned. Now, after I close this webinar today, there'll be a short survey. I'll ask all of you to please fill in the survey. Thank you once again. And hopefully, like I said earlier, we'll get to meet all of the attendees, all of you, all the in-house community. We'll bring them together and the 2022 in-house Congress in Dubai in person. Thank you very much. Have a great day ahead. Bye-bye.